So today we are going to go over the offer to purchase and contract. And remember, this is not a contract written by the North Carolina Real Estate Commission. This is actually written by
the Association of Realtors in cooperation with the Bar Association. They write it for the use of realtors. You'll see in just a moment down at the bottom of the page the realtor logo, which means that it is used specifically for the industry. You can't just give a copy of this to your friends and family unless you were involved in the transaction.
Exactly. So Chris, I know you love to start at the very top of this, and that's going to be with our title, the offer to purchase and contract. Why is that so important to you?
Well, it seems kind of simple, but it is one form that serves two purposes. When you make an offer, when the buyer typically makes an offer, it's an offer to purchase. Then when the seller accepts it and it's communicated back to the buyer, it becomes a contract. You don't need a separate form for that.
I agree. All right, well, let's go down to section 1, the terms and definitions, because for the next 2.5 pages or so, we're really going to be defining all of the different terms that are in the contract, and starting with the seller and the buyer, because it literally says this contract is between the seller and buyer. I don't see the word agent or firm or anything here. This is about the seller and the buyer. Yeah, that's it.
Keep in mind for test purposes, it's going to be extraordinarily important to know the parties of a contract. We'll get into some information later of why it's important to know that the agent is not part of this contract. For example, think compensation. Compensation does not show up here because, as Kandyce said, the parties are the seller and the buyer.
Exactly. All right, so moving on to section C, we have the property, and you'll notice we have the street address, but we also have a place for the legal description. The street address, of course, is 123 Happy Street or anything like that. We know what's really important is this legal description, and there's a place where you have, if you have it, a plat reference. There's the plat book and slide number. We got a PIN or PID number.
Yeah, remind them what the PIN stands for.
So that's the property identification number.
Yeah, typically a tax type concept. Yeah.
And your BIC will show you how to find that and where to get that information, right? And look, we even have talking about the deed book over here at page there, because we know that there are a lot of recorded documents at the Register of Deeds, so we want to refer to that recorded deed.
Yeah, simply put, my point on property description is more is better than less. It nails it down to one definitive property.
That's exactly right. Okay, so our next section is the purchase price, and that's going to be talking about, well, what is it that the buyer is offering to the seller, right?
Yeah, this is where your main negotiation is going to take place. And keep in mind, if that does change, keep in mind the concept of a counter offer. So this is our starting point, so to speak.
So if I was helping a buyer fill this out, I would start by putting in an offer price. So maybe it is $250,000. That's what I'm offering. And then I'm going to go ahead as a buyer and say, well, how much do I want to give you in due diligence? And how much do I want to give you in earnest money? So, of course, there's no set amount of due diligence or earnest money because that would be breaking.
Well, it's a breaking what?
I was going to say breaking just the rules about telling people there have to be minimums or normals for anything.
No standard.
There's
no
price
standard.
Fixing. Yes, no price fixing. Yep.
Okay.
So let's just say in this one we want to give how much in due diligence?
Well, I have a theory, but the reason I don't want people to follow my theory is just simply because once they get in the field, it's crazy depending on where you are, and it's going to be per transaction basis. So please, in the field, get with your mentor, get with your broker in charge. For the purposes of this demonstration, we're going to use $1,000 as the due diligence
So
fee.
this buyer is offering $1,000 in due diligence, and what if we do $2,500 in earnest money?
Sounds right.
Okay, so we're going to do $2,500 in earnest money. All right. Anything else you want to point out about that?
Only the fact that when I say that sounds about right, this is probably the most asked question that I get in classes. How much should this be? So please understand that is rhetorical. We just needed to have something that to fill in the blanks here. Don't assume that these numbers will always come up.
Now, I also like to point out here that this money, if we're talking about the due diligence fee, it is due by the effective date, so by the time you're under contract. And the initial earnest money, you get an option of either giving it with the offer or within 5 days of the effective date of the contract. And when you're filling this out in real life, you just have to make sure you check a box there.
Yes, and these dates are extraordinarily important because your buyer could in fact be in breach if they are not acting in accordance with when these delivery dates are. We'll show you that in just a moment.
All right. Now we do have our other lines. You'll see here that we've got additional earnest money. And when you get into a training class, you'll find out when sometimes you'll want to use initial earnest monies, sometimes you'll want additional earnest monies. But if you were going to have them, you might put it right here, and let's say it was $500. Now this $500 is what we call time being of the essence, which means it must be in no later than 5 p.m. Otherwise, the buyer would be in breach.
Yes, absolutely. And it also must be paid. Show them how it must be paid as well.
Oh, it has to come either by cash, official bank check, wire transfer, or electronic transfer. So, i.e., it cannot be a personal check. No personal checks here.
Yeah, extraordinarily important that you act by the time in question and also in the proper way. If your buyer is in breach, it's going to give the seller the ability to potentially kick them out of this contract and sell the property to someone else. And in a tight market, you don't want to make a mistake that's going to allow that to happen.
Exactly. All right, well, let's move on. The other lines are important, but not for what you all are studying for on this exam. So the assumption, the seller financing, builder deposit, that's things you'll understand later. So I'm just going to put an NA in each of these because we don't want to leave blanks on a contract. And that leaves us with our last line. This last line reads, the balance of the purchase price. So we've said so far, hey seller, I'm offering you $250,000. But I'm also offering you $1,000 in due diligence. I'm offering you $2,500 in initial earnest money and an additional $500 in additional earnest money. So I don't want to have to bring $250,000 to closing because I'm getting that $1,000, that $2,500, and that $500 back. I just need to bring the difference. So, Chris, you're the math whiz. What are we at there?
Looks like we have about $4,000 in credits. So if the offer price was $250, we would subtract $4,000, which would be the $1,000 plus the $2,500 plus the $500, and it would be $246,000 as the balance of the purchase price. Mm-hmm. While Kandyce is writing that in, there is actually a form called a 2G. The form we're looking at is 2T. It's a transactional form. G is a guideline form, and it'll tell you little technical features like this. If you have an opportunity to read that form, it'll be helpful in knowing how the attorneys who drafted these forms would like them filled out.
Mm-hmm. All right, so I think that's good when we talk about the purchase price. And then our next paragraph is one that I do think is important because it talks about what happens if the buyer doesn't give or they bounce or something happens to either the due diligence or the earnest money. Remember, this contract is not contingent on a seller receiving due diligence or earnest money. Once they're under contract, they're under contract. This paragraph talks about what happens if the seller doesn't get that money. So, Chris, what does it say?
Well, I probably get a question as a broker in charge on this topic about once a week. And basically it says if your funds were not good or timely, what's going to happen is that you are going to have to, there's actually an action that has to take place by the seller or the listing agent. If the funds are not timely or if the check balances is dishonored for some reason, then the seller or the listing agent realistically needs to give written notice. And keep in mind, if the contract says written notice, it means it does have to be in writing and delivered. And then this is the only place in this contract that you will see the word banking day. The seller will put in writing, hey, I need the money. And in fact, you must give it to me in one banking day. Would you like to describe what a banking day is as opposed to a calendar day?
Well, a banking day are the days that banks do business. Traditionally, that is Monday through Friday. So if you've got this request on a Sunday, that's not going to help. Calendar days are every day. Banking days are the days that banks are open.
Yeah, in theory, I'll have some people say, well, you got to get me the money in 24 hours, or you have to get it to me by this time, or whatever. It's the end of the next banking day. So make sure you understand this. Written notice, one banking day. And then if the buyer does not deliver the funds, the seller literally could give them written notice and kick them out of this contract.
That's right. It says right here, the seller shall have the right to terminate this contract upon written notice to the buyer if they fail to give those funds.
Yeah. And while Kandyce is moving forward in the contract, a quick story on this, and the reason I get questions about it as a broker in charge, Kandyce, is simply that the listing agents are coming to me and say, hey, I don't have the due diligence money yet. Or does that mean we're under contract? The answer to that question is yes, you are in fact under a contract. The buyer's in breach, but there's some remedies to that breach, so you have to take the appropriate step. The reason the listing agents are asking me is they want the buyer to be in breach
so that they can sell to a higher person.
They probably got a better offer.
Buyer.
Mm-hmm. Exactly.
Okay. So this next section, this is going to be section E, and I'm telling you this is going to be important. Everything in this paragraph you need to basically understand and know. All right? So I'm just going to start by reading it. The initial earnest money deposit, the additional earnest money deposit, and any other earnest monies paid or required to be paid in connection with this transaction. From here on out, we're just going to call those earnest money deposit. And I point that out because sometimes I've had students get confused because they're like, oh, well, they didn't say if it was initial or additional. After this point, anytime you see the words earnest money deposit, which I sometimes call the EMD, we just mean any earnest monies that you get.
Correct. It's what's known as a defined term, and if you look at it at the beginning of the paragraph, earnest money deposit is defined as those things that Kandyce mentioned. So it's okay at that point to call it the capital E, capital M, capital D, earnest money deposit.
And then those monies shall be deposited and held in escrow by an escrow agent until closing. Right? And then it's going to be credited to the buyer. So as long as the buyer buys the house, they will get their earnest money back as a credit at the time of closing / settlement.
Right. Absolutely.
Right? Now, there is an or right here. I don't know if you noticed that, Chris. Well, I know you noticed it. But that or says, oh, there's another time that you could get it back, and that's if the contract is otherwise terminated. Right? So that means if you terminate the contract, you got to figure out what's going to happen with the earnest money. We don't want it to stay in escrow limbo forever and ever and ever. Right?
Correct. And this, as you continue down in this paragraph, it's going to tell you what's going to happen to the earnest money. Now, having said that, if you want to play amateur attorney right here, you actually get to see how smart you are, because some of this stuff is actually intuitive. Now, the only thing I would say is it's not you determining whether the earnest money is going to go back. There'll be a broker in charge, and there'll be appropriate documentation. But what it says over the next several sentences is actually fairly intuitive about what should happen.
So let's say I'm a buyer. I've turned in an earnest money deposit with my offer. If the offer is not accepted, I want that money back.
Right.
Or if a condition in any of the conditions in the contract are not satisfied, I want my earnest money back as a buyer, right?
Yeah.
Now, sometimes the seller could breach. And if there's a breach by the seller, then the earnest money deposit needs to be refunded back to the buyer as well. And if the buyer still wants the house, they could sue the seller, and they could maybe ask for something like specific performance.
Possibly so, or damages. Interesting, both of the points that we just made. I always like to relate the contract back to something we talked about in class, and basically the buyer could ask for compensatory damages, right? They could be compensated, or they could get specific performance.
Exactly. All right, I want to highlight our next part in a different color because it is so important. We've talked about what happens if the seller breaches. The buyer should get back their money. Or if the buyer buys the house, the buyer should get back their money. But what happens if the buyer breaches, Chris?
Well, what's going to happen if the buyer breaches? Now, keep in mind, it's interesting that the buyer technically cannot breach during due diligence.
That is true.
So they can only breach after due diligence has passed. And let's say the buyer just changed their mind, to make it very, very simple. This contract is very specific about what happens to the earnest money if the buyer breaches, and that's that the seller should receive those monies as liquidated damages. And again, we talked about this in contract remedies. Liquidated damages, the damages will be liquidated at the earnest money. So if the buyer breaches, seller, how much is the seller getting?
The seller, they're getting their liquidated damages or their earnest money. In this case, that was, what was it, $2,500?
$2,500. Well, plus the $5,000 additional.
Plus the $500 additional, so that'd be $3,000.
And then that's all they're getting is the $3,000. Seller, there's no sense in suing the buyer and trying to get more.
So I like to point out right here, it says, you know what? If the buyer breaches, the seller gets that earnest money as their sole and exclusive remedy for that breach. Meaning, seller, when you choose or agree on an earnest money amount or due diligence amount, that's all you get. It better be enough to make you happy and go to sleep at night.
I think that bears some explanation when you're in the field and talking to a seller that, hey, literally up until the time of closing, if the buyer walks away, that's it. That's all you're getting. So make sure it is a number that they'll be happy with if the buyer walks away.
I definitely agree. And then this paragraph, which is full of so much good stuff, it points out at the end, if there's any legal proceedings, if anybody sues somebody because they were supposed to get their earnest money and they didn't get it, the person who loses is paying for the court costs and the attorney fees.
Correct.
Right?
Yep.
So I think that summed that up pretty well, yes?
Yeah, you're right, though. That is a very important paragraph.
Okay. So our next paragraph is the escrow agent. And this is setting up who's going to hold the earnest money. A lot of times in our pre-licensing class, we just assume that it's going to be the listing agent's firm. But does it have to be?
No, it doesn't have to be. And it's interesting, when you look closely at the agency agreements, the listing agreement actually says that it'll be the listing firm unless otherwise stated in the contract. So oftentimes you see that it is otherwise stated in the contract, and oftentimes it's an attorney that will hold the firm. Either of these are okay.
Hey, Chris, did you notice that there's this blue paragraph underneath? And what it's basically saying is, you know what? If there is any disagreement on the earnest monies or about the earnest monies, we, whether it's us as the listing agent or the attorney, we cannot disperse them. So if somebody wants their earnest monies back, whether it's the seller because the buyer has breached, or the buyer wants their earnest money back because they've walked away during due diligence, in that little note it says, hey, these monies are going to be held up until there's agreement.
Yeah, this used to be a big deal, but notice the sentence that Kandyce had highlighted just a moment ago, that we have what we call the big stick in the contract now, and what it says is, hey, look, if you're going to bring suit against somebody, you better be right, because if you're wrong, you're going to end up having to pay your fees and their fees. So we don't have as many disputes as we used to. Having said that, what this paragraph literally says is, in the event of a dispute, Kandyce, do you mind just circling the word dispute there? Because I want everyone to understand that, look, if everything goes well, then the fact of the matter is that if the buyer breaches, the seller gets it. If the seller breaches, the buyer. It's only in the event of a dispute that what's going to happen is we're going to have to hold these earnest monies, and what I mean by we is your broker in charge or the escrow agent. We're going to hold these earnest monies until we get a written agreement of the parties. Now, again, if it says written, it must be in writing and agreed to, signed by both parties, written agreement of the parties. If a court tells us what to do with it, then we will disperse it according to a court of competent jurisdiction. And then there is a third remedy as well, where we will simply hold the money. We will give both parties notice, and then we'll hold the money for 90 days. At that point, if there's no agreement, we'll just turn it over to the clerk of court, and they can fight it out with the clerk of court at that time.
Did you know if they don't go for that money after a certain amount of time, and I don't remember the number of days, then it basically goes to the state?
Yeah, a vocabulary word that we have early on, that is sheets to the state.
It is sheets to the state.
Yep.
All right. So our next section, and I'll move our contract up here, our next section is really important because it is a part of our licensing law. We know that we've got to tell people what happens with any interest if you're putting your escrow monies into an interest-bearing trust account. So notice this entire paragraph is caps, and it says, you know what? This is going to be in an interest-bearing trust account, and we're going to keep the interest.
Yeah, it's to take it back to license law, the question is simply this: can a firm have an interest-bearing trust account? The answer is
yes, they can.
As long as they have permission of the parties, and that's what we're getting in this place right
And
here.
it's right there.
Yep, perfect.
Okay, tell us about Section G, Chris.
You know, it's got some very interesting language as you go through it, but I'd like to brief it and just be as simple as possible. The effective date of this contract, and notice again, it's a defined term. The effective date is defined not when an offer is made, not when it's accepted, but when it is offered, accepted, and communicated back to the offering party. So we did this exercise in agency class as well. But when the buyer makes an offer, they could terminate that offer literally at any time.
That is true.
Yeah.
Any time prior to being told they're under contract.
Right. Now, when the seller signs it, technically it's still not a contract in most cases until it has been communicated back to the offering party.
So if we had to sum that up, what we're saying is here is the language in the contract that says we are not under contract until all parties have signed or initialed any change if there's a counteroffer, and the last person who signed or initialed tells somebody on the other side that they have signed and initialed. Until we have that communication, we do not have a contract, and that effective date is going to be the date of that communication.
Cool.
So if I'm a buyer and you're a seller, if I give you an offer on Friday night, you sign it Friday night, but you don't tell me that you've signed it until Saturday morning, our effective date would be Saturday.
Morning. That's correct.
Right.
And the reason that's important, think back to page 1 when Kandyce said that the due diligence money is due on the effective date of the contract.
Which means you would have to have that due diligence money by Saturday.
Correct.
Now, again, you're going to get training classes, hopefully, and when you do, you'll have discussions about how to give the due diligence, when should I give it. All of those things will be answered in a training. This is just about the test, and for the test, it is imperative you understand that you are not under contract until all the parties have signed and everybody knows, or really that the other side has said, yay, we've signed, and now we have an effective date.
Perfect.
All right. Can we move on to due diligence?
Yes, and I don't know about you, but I actually take the next 3 paragraphs together.
I actually was going to say the same thing.
Perfect.
So I will go ahead and put them in a different color. We know that we have due diligence fee, and the due diligence period. So Chris, hit us up with that.
Okay, well, notice in the first part there, it just simply describes what due diligence is, and for simplicity's sake, let's just simply say that it is the buyer's right to do investigations on the property, or not, for that matter. They can
choose not to.
Yeah, they can do
because it's their choice, right?
And then when you get to the due diligence fee, I want you to think of the due diligence fee as an exchange of money for time, of consideration for time. Mm-hmm. So the fee is a fee that is paid to give the buyer a period, which you'll see in the next paragraph, to do the investigations mentioned above.
Exactly. It's a negotiated amount, if any, so it could be 0, couldn't it?
It could.
Right? Paid by buyer to the seller with this contract for the buyer's right to terminate the contract for any reason or no reason during the due diligence period. So really they are buying an amount of time, and within that time period, they have gotten the right to cancel or terminate for any reason or no reason whatsoever.
Give me an example of a reason why they might terminate.
Maybe there's a huge foundation issue, and even though the seller's willing to fix it, they just don't want a house with an issue.
Give me an example of no reason.
I woke up this morning, it was a bad hair day, and I don't want to buy your house.
And what did that cost them to walk away?
In order to walk away, it's going to cost me as the buyer the due diligence monies, but I would get back my earnest monies.
Perfect.
All right. The only other thing I think that somebody needs to make sure they understand is that there is going to be an effective date. There's going to be this due diligence period with time being of the essence, and it's during that due diligence period that starts on the effective date that a buyer wants to do all their due diligence or do their inspections. I know we're going to talk about it later, but I'd just like to say it up front. While they're buying that time and they're buying the right to walk away, you want to make sure your buyer understands they need to do inspections.
Yes, now they're under no obligation to do it, of course, but they lose all their leverage after the due diligence period expires, so it makes sense to do it within that period of time.
And that's 5 p.m., time being of the essence. Anything else you want to add about due diligence? I know we'll see it again later.
Yeah, only that is a big deal. Understanding the language, understanding that its time is of the essence, and understanding what the buyer will lose or not lose based on their actions.
I mean, that's why it's in Carolina blue, because it's so important.
There you go.
All right. So moving on, we've got 2 words here. We've got settlement and settlement date. They are important, but we're not going to put them in our Carolina blue. We'll put them back in green. So settlement date, and then I'm just going to scoot up a little bit. You've got closing, because I know in the real world we tend to use these words interchangeably, but Chris, are they the same?
No, settlement's a process. Settlement's a process when you're collecting documents. The attorney's collecting documents. They're doing title investigations and things like that. Settlement date is when everybody's getting together, signing the documents. You may do it.
It's a little party.
Right. You may do it together. You could do it remotely. I mean, these are just the date that we're shooting on, that we hope the exchange of the property is going to take place. But when we get to closing is a big deal.
Yes. Because when we say closing, we don't mean just, oh, all of us got together at the settlement table. What we mean is, okay, we've had settlement, right? Then there was another title search that the buyer's attorney does. Then we have to make sure the closing attorney got permission to disperse the funds, and then they record. They are definitely going to have to record, and I'll put this here, recordation. They've got to record. And until we record, we do not have a closing.
Yeah, it's I like to say, just to keep it short, that closing is defined as date and time of recordation of deed.
Yep.
All that other stuff is interesting, but until it's recorded, we have not exchanged possession of the property. And I don't know if you do it at this point, Kandyce, but I always have people write in their notes right here, the law that it's talking about a little bit farther in the paragraph is the Good Funds Settlement Act.
All right, I'll just make a note here. It is the Good Funds
Settlement Act. And it just supports the idea that don't disperse funds until appropriate settlement has occurred.
Exactly.
I'm sorry, appropriate closing has occurred.
Well, I know what you meant.
Thank you.
Okay. Now, it's in red, so we should talk about it. Chris, do I have to be an attorney to hold a closing in this state?
No, interestingly enough, you do not have to be an attorney. However,
big however.
Yeah, the state bar is making a comment here that they believe certain work must be done by an attorney, as it is a legal action.
Yeah. So in story here, let the attorneys do the closing and settlements. People, don't take on that responsibility.
Perfect.
All right. So we've got some more words we need to define. So we're going to go with assessments. If you had to explain assessments, what would you say, Chris?
I would say it's a tax levy for a one-time improvement. It could be a public government entity. It could be an HOA type entity, but it's an assessment or a levy for a one-time improvement.
And we have 2 different types of assessments in this contract: our proposed special assessments and our confirmed special assessments. Proposed means we're still waiting to find out if it's definitely happening. Confirmed is it's definitely happening regardless of when it's due. We know that money is important. And I'll point out later in the contract where that is.
Now, beginning with the fixtures and exclusions paragraph. Now, at this point, this should not be a mystery to you. Notice that we're in the offer to purchase now, but this will mimic the same paragraph that we had in the listing agreement. We've already had a conversation with the seller about these items, and here's the deal. If the contract says it's a fixture, then it is in fact a fixture.
Yes.
One interesting thing to put out, you do not have to, if the seller doesn't have one of these items, for example, a generator, you don't have to mark it out. It says the following items, if any, and if owned by the seller.
Exactly.
But otherwise, they're going to go with the home, and if they would like to keep any of the fixtures, what would they do in that case?
If you go up a couple of pages, or just say really a page, you're going to see other items that do not convey. So if the seller has items they do not want to leave that would be considered a fixture from the previous page, we're going to go ahead and put them here.
Yeah, can you give an example?
You know what? I can. Let me scroll back, and you'll notice right here that it talks about mirrors. So notice it says mirrors attached to the walls, ceilings, cabinets or doors, and all bathroom wall mirrors. You know, I actually had a deal once where the seller did not want to leave their bathroom mirrors. So if that was the case, we're going to go ahead and write in other items that do not convey, and we could just write bathroom mirrors. Now, I know in real life, I would probably want to be more specific, but for right now,
Sure.
I think that works.
Yes, and the experience I've had have involved things like chandeliers and other light fixtures, the exact type of thing that we talk about in class.
So let's say, can I spell chandelier? Chandelier? Well, if that's not right, you can, sue me later. All right, let's move on to personal property because it does kind of similarly go. We know our fixtures are personal property that have been permanently attached to our real property, so it's going to convey with the real property. Our personal property is anything that's not real property. And sometimes the seller wants to leave those things. Give me an example, Chris.
Yeah, you know what? Rather than get creative here, I'm going to use the most popular example. It's probably the refrigerator.
Okay.
In most cases, the refrigerator is not a built-in, so it would be personal property, and oftentimes the buyer wants it. If the buyer wants it, he better ask for it in that paragraph right there, regardless of what the MLS says.
And sometimes I'll see washer dryer here.
Very popular as well. Yep. And notice, if you don't mind underlining, that they are at no value at closing.
I was about to say that, at no value. So there can't be any value. Oh, well, we'll give you $251 if you leave the refrigerator, but $250 if you don't. Nope, this is no value.
Correct. It becomes a big deal in underwriting for a lender. If they see a lot of personal property stacked up there, lenders are loaning money on a home, not a loan, not on a home and a bunch of accessory personal property.
Exactly. Okay, let's move to section 4, our buyer's due diligence process. Now, we did just talk about this, and I'm going to go ahead and put it back in our Carolina blue because it's that important. This buyer's due diligence process, and it says, warning. It even starts with warning. Buyer is strongly encouraged to conduct due diligence during the due diligence period. Meaning, buyer, if you want to know anything about the house, now is the time to find out. Okay?
Yeah, this paragraph, while it is really, really important, I actually go over it fairly quickly in pre-license, and here's why. A really good agent was already recommending that these items be done. You'll notice as we go down below that there's a list of investigations that the buyer should probably consider. But what the attorneys thought was by including it in the contract that buyers would look at it and say, oh, it's very important to get that done. So it's really to support agents is what it amounts to. But yeah, buyer, do these things. Do it during this time frame.
And let's say I'm a buyer, Chris, and you're the seller, and something happened. I had a family emergency, and my 3-week due diligence period is now down to 4 days, and I haven't gotten a home inspection. Do you have to extend it?
No, the sellers are under no obligation to extend.
They want to do it prior to the expiration of due diligence, and the seller's not obligated to grant an extension.
Correct. I get this question a lot as a broker in charge. The end of my due diligence period is coming up and the seller has not responded. What do you think I should do? I say, well, the seller has responded. They're saying they're not fixing anything. That's what you should consider.
Exactly. Now, a seller could choose to respond, and for that they use the agreement to amend. But a seller does not have to respond or fix anything, and they can drag their feet. There's nothing you can do about it, buyer, except walk away before the end of due diligence if you want that earnest money back. Because if you walk away after that due diligence period, which is time being of the essence, you will lose that earnest money and the due diligence money.
Yeah, interestingly enough, I have a lot of agents who will write in this contract that they will say the house is being purchased as is. Well,
it always was.
All houses are purchased as is. If you can negotiate repairs, that is awesome. Having said that, you can't assume that you can negotiate repairs.
Exactly. All right, let's move on so we can get out of our favorite blue. Go back to green, and we'll point out that, okay, the buyer is going to want to get a loan, or basically, if they're going to get a loan, make sure that during the due diligence period, they've gotten as much information as possible to find out if they can, in fact, be approved.
Yeah, years ago, this was a change in the contract. Contracts, 10, 12 years ago, used to be contingent upon your ability to obtain a loan.
But now it is not contingent on obtaining a loan. So if you find out after your due diligence that it doesn't appraise, buyer, if you can't buy the house, you're losing your
earnest money. If it's after due diligence, there no longer is a contingency.
Exactly. All right. In our next section, as you see, and I'll scroll it up here, we have, well, here are some things that the buyer could look at during due diligence. So these are going to be our property investigations. They are going to, of course, inspect whether it's just the condition of the house, pests, anything like that. They want to review any kind of documents. And what kind of documents would they be reviewing?
Well, it talks a little bit in here about owner association documents. I will warn you that in the field I'd be highly careful with this because let's say that you know that your client has a boat that they're going to park at the house. You know that they have a work vehicle they're going to park at the house. You may want to investigate that literally before making the offer, because in most cases that's not going to be allowed in a subdivision, and I would hate for them to have due diligence on the line if it's something you could have figured out before.
Exactly.
They made the offer.
They're going to take a look at insurance, of course, if it appraises. Do you suggest that buyers get surveys?
I recommend 100% of the time.
Me too.
Well, let me rephrase that. Maybe not on a condo, but
That's true.
Outside of a condo, I recommend it 100% of the time.
Because any encroachments would be found on that survey.
That's right, and they come up so often.
Zoning and governmental regulations. So are there any zoning rules or ordinances that would stop the buyer from doing something they wanted? Of course, we know it's a material fact whether or not it's in a flood hazard. Do they have utilities, and what's the access? How much are those utilities? And we also know we have to disclose whether or not the streets are publicly or privately maintained.
Yeah, so if you remember back in chapter 2 or 3, we spent a lot of time talking about the significance of this, and this is an issue that has raised its head a lot of times in the last several years. So it continues to show up in our contracts. Hey, buyer, check it out. It could be important. It could be important to your financing. Could be important to future maintenance of the road. Exactly.
And then last but certainly not least is this fuel tank. We just want to say, if there's a fuel tank, what's in it? Who's, of course, the contract says if there's any fuel in it at closing that belongs to the buyer, but what does the seller want to do? And maybe it's a rented fuel tank. So we got to talk about that. Make sure that you do your inspections, buyer, on what's going on with the fuel tank. And then I'm going to move on that you notice that section D says repair, improvements, negotiations, and agreement. And I think we've already covered this. The property is being sold in its then current condition. So the seller doesn't have to fix anything. The seller is under no obligation to tell the buyer about anything in the house. This due diligence period gives the buyer the opportunity to try to negotiate some repairs. And if they don't like any of the answers they get, sorry for you, the house is sold as is, and you should walk away before the end of your due diligence, buyer.
That's right. It just simply repeats the fact that it's been a theme of this. Do your diligence if you choose to. Do it during the due diligence period when you have the most strength, and then either stay or walk during that time. We'll get to the buyer's right to terminate in just a moment.
In fact, I'm going to go very quickly and just say, you know what, buyer, while you're inspecting the house, if you break it, you fix it. Right? I'm going to jump down to buyer's right to terminate because you just talked about this. The buyer shall have the right to terminate this contract for any reason or no reason by delivering to the seller, and you keep pointing out our written notice of termination during the due diligence period. Okay? So you, buyer, have the right to terminate as long as you do so before the end of the due diligence period, time being of the essence. And remind us again what time being of the essence means.
That means that actions that are time is of the essence must happen on or before that particular date. We've talked about 2 time is of the essence periods in our contract so far. Additional earnest money, which doesn't involve a lot of clarification, but the due diligence period is, in fact, not only is it time is of the essence, but it's 5 o'clock on the due diligence date. So act by that time or lose your right to act.
And then when the buyer buys the house, you know what? It's yours as is, where is. It's yours however it is at that day.
It's my favorite line in the whole contract. Closing constitutes acceptance. This is not property management, buyer. This is now your house.
All right, any questions about any of that in that section about the due diligence, Chris? Anything you want to add?
Not really. Like I say, it's a great starter checklist. If you're a new agent and you need a starter checklist, it gives you an idea of what the buyer should be doing during due diligence.
Right. So I'm going to scoot us on up to this buyer representation section. What are you thinking about this, Chris?
Well, the first thing that comes up under buyer representations, and I'd like you to pay attention in this contract, there's a difference between a representation and an obligation. A representation is just simply something that you are saying, hey, this is what I believe to be true. And the first thing that comes up here is the loan. Now, to relate it to something we've talked about in class, I believe that the buyer's loan, if they have to get one, is a material fact that the seller should be aware. If I'm selling my $250,000 house, I want to know that you have the ability to come up with $250,000, and this is where we show it to the seller.
I agree, and I think the people who wrote this contract do too, because there is a section here where you have to, as the buyer, admit whether you do or don't have to sell or lease other real property in order to get this house. So we don't have a contingent contract or anything like that anymore in North Carolina, but a buyer must be honest about whether or not they can buy the house without having to sell another home.
Yeah, and while these questions look tricky, your buyer will be working closely with a lender, and you will have access to that information. If you ask the buyer, they'll give this to you, so you'll know how to fill in the blanks of this. It won't be a mystery.
Yeah, and I mean, the rest of this little section is just talking about, hey, buyer, if you do have to sell a house, is it under contract or is it not under contract? And just give us some more information. Because at the end of the day, this contract is not conditioned upon the sale or lease or closing of a buyer's other property.
Yeah, think about this, Kandyce. If I am a seller and I get 3 offers, isn't it significant how the buyer is going to pay for my house for me to consider which one is the strongest?
Would I rather have a cash deal or somebody getting 100% financing or somebody who's only needing to borrow half of the money? Who knows?
Correct.
So the seller definitely wants to know, and a buyer cannot lie in this section. They have to at least say, if I can't buy the house without doing something, getting a loan, here you need to know.
True.
I'm going to scoot on up, and let's get to this Residential Property Owners Association disclosure statement. Chris, what do you tend to call this? And I do too.
The RPOD.
The RPODs, because Residential Property Owners Association Disclosure Statement, the RPODs, all right?
And we say it 8,000 times a day.
Oh my gosh, do we? So I'm going to let you sum it up.
Well, at this part, we're just simply acknowledging whether the buyer received these forms. A diligent listing agent would have posted these on the MLS, and so that the buyer can pull them down, the buyer's agent, of course, can pull them down and give them to the buyer. Now, the important part about this is, even as a buyer's agent, I want my client to receive these so that I can check the box off here that says that they received it. Because if a buyer does not receive these before they make the offer, they're going to be entitled to a 3-day right of rescission.
Exactly.
So let's get them the information. Let's have them be able to check box number 1, and let's eliminate this ability to walk away for lack of receiving the RPOD or the MOG. Very simple to accomplish.
Now, I know we talk about the RPODs in a different section, like in a class.
Absolutely.
But there's that 3-day period, and it's not just 3 days. It's either 3 days from when they got under contract, 3 days from when they received it, or 3 days or up until closing or move in. I don't want to go into detail right now, but they do have that 3-day period to walk away. Right? And very similar to that, we have our MOG, or our mineral oil and gas rights disclosure statement, which is very similar, except the seller is saying whether they have sold off or given off the mineral oil or gas rights, or if they intend to. And again, if that buyer does not receive a copy before they make an offer, then they have that 3-day period to get out. Again, a buyer should receive this before they make an offer. This 3 days is only if they don't have it. So we really do want that buyer to go ahead and be able to check the first boxes.
Correct. And again, a different lecture here, but while on new homes the RPOD would not be required, the MOG would be required if it was a new home, as well as most resales.
Exactly. All right, can we move on to the next section?
Absolutely, please.
That's going to be our buyer obligations. And as you pointed out, before we had, sorry about that, Before, we had our buyer representations, and now we have our buyer obligations. This is what the buyer's obligated to do. They are obligated to pay for the proposed special assessments. There's some things they have to pay for at closing, or I should say settlement. So anything having to do with the loan, if there's going to be an appraisal, title search, title insurance, recording the deed, if there's any paperwork that needs to be done so that they can get a loan. I mean, anything else that's really important there?
Not really, other than the fact that these are things associated with the buyer's diligence. So common sense would say that the buyer would pay for them.
The buyer's responsible for paying for all the inspections.
Yeah, before you do roll forward, though, I want to remind you, make sure you know the definition of a proposed special assessment. Remember, as we said earlier, this is formal consideration. And so I would treat it as a material fact. The buyer has a right to know that there's a proposed one coming. These are not rumors or innuendo. These are under formal consideration, but not yet confirmed.
All right. Moving on. Our section 7, we've now moved on to our seller representations. So our seller needs to say how long have they owned the house. If the house is built before 1978, they need to give a lead-based paint addendum, right? And the seller needs to point out whether or not they know there are any proposed or confirmed assessments. You want to add anything there?
Just to wrap up what we started just a moment ago, a confirmed special assessment, please note that is paid by the seller if it occurs, if it is confirmed at any point prior to the closing. So the buyer takes the property subject to proposed, but the seller pays for confirmed. I would highly imagine that that will show up again at some point.
We're going to move on and see where the owner gives permission for the buyer, the buyer's agent, the attorney to find out what they need about the owners association. And there's information they can fill out about who to contact. But it's also, you're going to see this information on the RPODs as well.
That's right.
Okay. And after our seller, what am I trying to say?
Representations.
And after our seller representations, you have our seller obligations. So there's one section here that I think is so important. So I'm going to go quickly to it. I mean, I do want to recognize that the seller has to give reasonable access to the property. They have to remove their personal property and their garbage. But really, the one that I love and so important is this section G, the good title and legal access. And that says the seller shall execute and deliver a general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple, marketable, and insurable title without exception for mechanics liens and free of any other liens, encumbrances, or defects, including those that would be revealed by a current and accurate survey of the property, except ad valorem taxes, utility easements, and unviolated covenants, conditions, and restrictions that do not materially affect the value of the property. Whew, that's a mouthful. So what does that all mean, Chris?
Well, it is very important. Going back to the name of the provision was seller obligations. The significance here is if they can't do all of what Kandyce just read, then the seller would be in breach. And as we talked about in the Earnest Money paragraph, what's going to happen if the seller is in breach? They're going to have to give the buyer back their earnest money, their due diligence money, and then also it'll talk in just a moment that the seller would also be responsible for returning to the buyer any monies that they have spent in an effort to acquire the property. Hey, it's your fault. You can't deliver title, so you need to make it right with the buyer.
All right. I did jump to that section. Was there anything else that you wanted to hit on? I mean, we talked about removing the seller's property. They have to give access. Oh, I do want to say that the seller is obligated to provide existing utilities at their cost up until closing. So the buyer has to be able to do inspections.
True.
All right. Let's move on then. So the seller has to pay. And you're going to want to remember this for settlement statements, closings, closing disclosures. They pay for preparation of the deed, right? And they're going to pay for county excise taxes, any kind of local fees that are going to need to be paid.
Correct, yes. And like you said, this will come up again when we start doing the closing statements. There will only be a few things on the seller's side, and we're defining some of them here.
If the buyer wants the seller to pay any closing costs, then that would go here in this section. And notice you could just put in an amount, whatever that may be.
I would encourage you to be careful with this in the field, not so much for test purposes. I get a lot of questions about, well, how much is that number? Completely negotiable. Completely negotiable. There's no compelling reason that there be any, but if the buyer needs them and requests them, that's where they do it.
I'm going to scroll up our contract here, and I want to jump to payment of confirmed assessments, because as you just mentioned, Chris, the seller is responsible for all confirmed assessments. The buyer is responsible for any proposed, right? And if there are any repairs that the seller agreed to do, they must be done in a good and workmanlike manner.
Perfect.
Right. Now, Chris, will you talk about this seller's failure to comply, or if they breach?
Well, I'm sorry I bumped into this just a moment ago, but basically this was the conversation about the fact that all of these things, all these obligations that we just mentioned, if the seller is unable to perform those, they are in breach, and the penalties of breach are that the buyer may terminate, and if the buyer does terminate, they get back earnest money, due diligence, and of course they would get back those items that they have spent in an effort to acquire the property, such as inspections, appraisals, surveys, etc.
So our next section is prorations and adjustments. And prorations happen a lot on this test as far as math is concerned, right?
Yeah, on this section, I don't spend a whole lot of time talking about it during the contract, because what will happen is when we start doing our closing statements, one of the things that I will mention is that, hey, this is addressed. Why do we prorate taxes on a calendar year basis? Because it tells us to in the contract.
So our real property taxes are prorated. Our rents, if there are any, if somebody's buying a house that's already rented, the new owner is going to have to honor those leases. So we need to split those rents. If there's any owners association dues that we need to split, those things need to be prorated. And who pays the day of closing? It is the seller.
The seller's responsible for the day of the close. Sometimes he pays it, sometimes it's a benefit. In rents, it actually ends up benefiting the seller.
Yeah. All right. On our next page, we've got questions about whether or not the seller is going to give a home warranty or is not going to give a home warranty. Either way, just fill in the information as needed. And then a big section is this risk of loss and condition of property at closing. Go for it, Chris.
Well, it's very simply put, but it has a lot of issues that could arise. Very simply, the seller is responsible for the property up until the time of closing.
And closing is recording.
Date and time of recordation of deed. Now think about this for just a moment. What if the buyer moves in early, a buyer possession prior to closing? The seller's still responsible. The contract says so. What if the seller stays in the property after closing, a seller possession after closing? Well, at closing, possession changed, so the buyer would now be responsible.
It's not something we want to take lightly. Definitely, if you have a buyer moving in early or a seller staying later, talk to an attorney about what that means and make sure the buyer understands it's not their house until after closing. It records, and seller, after it records, it's no longer yours. So talk about insurance and all of those things.
Bingo. This is the type of question that blends two chapters, and so insurance would clearly come up in a question involving this.
Exactly. Okay, let's talk about this delay in settlement. And maybe the first thing I want to talk about is, you'll notice in this paragraph, there are some words that aren't here, which is time being of the essence. Closing, that settlement date, that closing is not time being of the essence. And this paragraph basically, if I had to sum it up, says, look, we'll allow either party to have a 14-day window between when they said they wanted settlement to be and when it actually happens. We're going to give you a 14-day-ish, kind of like when I say, hey, you want to meet me for lunch at 12, Chris? It's 12-ish. We're giving a 14-day-ish period.
Now, the buyer should not go into a contract planning to use the 14 days. They should, in fact, act in good faith. And after the 14-day period, they will be in breach if they do not close. But because the closing date was not, or the settlement date was not, time is of the essence, what we've done is defined what we consider to be a reasonable period of time.
14 days.
14 days, perfect.
Okay. And we just mentioned this, that, hey, possession does not happen until after closing. So if there's a delay in settlement, buyer, your possession is going to be delayed, because buyer, you don't get possession until after closing, unless we go through and we make other arrangements. Right?
Yeah,
and there's a form for that.
I was going to say, that's what I tell my class exactly. If possession is anything other than closing, we have a form for that.
In fact, I like to point out that we have all of these other addenda that we can talk about at another time, but there's different addenda that we might add, maybe like an FHA VA. We talked about the lead-based paint. Right now is not the time to get into it, but there are definitely some addenda that you should recognize.
Yeah, and you'll notice in the paragraph below that the brokers do not draft these contracts. They do not draft these provisions. Look first to see if we have one drafted by an attorney.
And once we do have an addenda or a contract available, all we do is fill in the blanks.
Perfect.
Okay. So I think we're towards the end now. We know that this offer to purchase and contract cannot be signed unless you have written consent of all the parties. If it's a 1031 tax-deferred exchange, the buyer and seller are agreeing to cooperate, and very quickly, a 1031 tax-deferred exchange just means whoever's selling the property or buying the property is really got some tax benefits going on, and the other party wants to make sure that they're not going to have to pay for anything extra.
Correct. Yeah, I just refer to it as a tax strategy for an investment property, and obviously the one doing the exchange should be responsible for the payments.
Section 17 are parties, and we already know that our parties are the buyer and seller, but also the buyer and seller and their respective heirs, successors, and assigns. Most importantly, I want to say the word heirs. Termination of a contract does not happen simply because a buyer or seller dies. Once a person is under contract using this offer to purchase and contract to T, then their heirs are also responsible for following through.
You clearly are going to get tested on this. What happens to an offer when someone dies? What happens to an agency agreement when someone dies? What happens to a contract when someone dies? And in the contract, if someone dies, their heirs have responsibilities based on the language here.
Exactly. So I want to point out that this is the entire agreement. It helps if I give us the right color here. This is the entire agreement. So anything that we want to change, add, delete must be in writing and signed by all the parties. All right?
Yeah, we have a concept referred to as the parole evidence rule that says the written word will always take priority over any unwritten agreement to the contrary, and this is being repeated right here.
Exactly. And I'm going to move on. And remember, you talked about days, computations of days and time. So we mean consecutive calendar days, including Saturdays, Sundays, and holidays, whether federal, state, local, or religious, except for that one on page 1, that one place where we said banking days, for how many days the buyer has to get good funds to the seller.
That's right, in the event that their due diligence check bounces, for example.
Exactly. All right. So this is the end of the contract, and you'll notice we've got a place for the buyers to sign and the sellers to sign. You've got some dates, and possibly maybe it's an entity like an LLC or a corporation that's buying and selling. Then you have a place for them to sign on behalf of that corporation.
The only thing that I would add about the signatures is if there's 2 sellers on page 1, there needs to be 2 sellers here, 2 buyers, etc., etc. Otherwise, it's incomplete and possibly not binding. So be careful with that.
Great point. Great point. Okay, so the wire fraud warning. Tell us about that, Chris.
Well, because wire fraud has been so prevalent over in the industry the past several years, in all of our documents, notice the consistency with this. Agency agreements, and now you're seeing it in the contract as well. Hey, buyers and sellers, you be very, very careful when you're wiring funds. I will not send you an email with wiring instructors. You need to talk to the attorney about how to wire those funds.
Very good. All right, our page 13 is our notice information. So this is where an agent is saying, you know, any of these places, any of this information I fill out is where you can tell me, hey, we're under contract or not under contract. Remember, if you are an agent and you put a buyer or seller's information in here, you're saying it's okay to reach them directly, but have a conversation with your BIC as to how you want to handle that. And I want to also point out that there's a place for the agent's license numbers. Why is that there, Chris?
Well, it's a commission rule.
It is a commission rule. Oh, is it a commission rule?
It is on the agency agreements, but I don't think it is.
Okay, well, it's still important, even if it's not a commission rule, that you have it there. And you do have to mark that if it's going to be a designated dual agent, if that is what's happening. And notice the firm has to talk about whether or not they are a dual agent, right? And so then we roll on to the very last page, which actually isn't part of our contract per se. It's just where people can acknowledge if they receive due diligence fee. Maybe you're the listing agent and you got due diligence fee, or maybe you're the seller saying, I got the due diligence fee from somebody. And then, of course, with our escrow agent, acknowledging whether they got initial earnest money or additional earnest money.
I suspect your broker in charge will give you some clear instructions on this, because anytime you touch money, it needs to be accounted for, and this is a great way to do it.
Exactly. So I can't believe it did, Chris. We went through all 14 pages, and we hit everything any pre-licensing student would reasonably probably need to know for this test. Anything you want to add?
Just this. There's no way you can memorize these contracts. Actually, it wouldn't do you any good to memorize them, because they always change on July 1st.
This one's going to change come this July of 2020.
Right. So relate it to something you talked about in class. Understand how to fill it out. Your clients deserve at least some guidance on how to fill the form out. If it's a technical issue that gets over your head, you're clearly going to consult an attorney.
Exactly. All right. Well, this has been great, and we'll see you next time.
Thank you.